Mr. Barr.
Thank you, sir. Inquiring publicly into the actions of an undercover police unit, which was gathering intelligence about political activists half a century ago, is no easy task. However, we have now reached the point at which we have obtained, prepared for publication, and adduced evidence about the formation of the Special Demonstration Squad, the SDS, and its operation from 1968 until the early 1980s. We have investigated 56 undercover officers, UCOs, all of whom joined the SDS at some point between 1968 and 1979. We obtained witness statements from 36 of these officers, 16 former undercover officers and 2 risk assessors gave oral evidence in open hearings, and a further 5 gave closed oral evidence. 21 civilian witnesses provided witness statements, and 12 of them gave oral evidence. We have also investigated the management of the SDS, obtaining witness statements from 13 former managers or administrators who served within the SDS, and calling 7 of them to give oral evidence. Witness statements from 6 former police officers who were involved either in the SDS's higher chain of command or as disseminators or consumers of SDS intelligence have been put into evidence, as have 4 witness statements from former Home Office officials, all of whom discharged functions with some connection to the SDS. The evidence of witnesses is valuable and on some issues invaluable. However, at this remove in time, there can be no doubting the utility of contemporary written records. The discovery of very extensive surviving records from the Tranche 1 era enables a much more effective forensic exercise than would have been possible had we had to rely upon human memories alone. I do not propose either to rehearse or to analyze in detail the evidence that we have received. We have already produced detailed openings for each of the hearings in Tranche 1, as well as submissions on the law, which it would serve no purpose to repeat. Rather, I shall summarize the broad conclusions, which it appears to us can be drawn from the evidence. On issues in which core participants have a particular interest, they or their counsel will make more detailed submissions. I shall, in places, seek to identify emerging themes and trends, although I am conscious, sir, that for the purposes of your interim report, you may decide that some such issues are best left until you have heard all the evidence. As in previous submissions, I shall also use SDS throughout to refer to the undercover unit, which, at least in its early years, was referred to formally and informally by a variety of other names. Metropolitan Police Special Branch was already gathering intelligence about groups and individuals on the far left of the political spectrum, amongst others, before the Special Demonstration Squad was established. It collected such intelligence from numerous sources. A common source was plain-clothed police officers who attended and reported on meetings held by activists. Such officers could attend public meetings, but were not always successful in their attempts to attend private meetings. They either did not deceive others as to their identity or did so briefly, using only temporary and superficial cover. Intelligence was recorded in the same format and on the same forms as were first used by the SDS. Special Branch used these sources to build up a detailed picture, not only of the groups, but also their members and sympathizers, especially leading members. In 1967, and particularly 1968, there was an increase in violent political demonstrations both in London and across Europe. Especially prominent were massive demonstrations against the Vietnam War, a cause which united not only far-left groups, but also large sections of the public. The shocking violence and narrow margin by which protesters were prevented from breaking through to the American embassy on the 17th of March, 1968, prompted great concern within the government and the Metropolitan Police Service. Both were determined to avoid a repeat of the violence. The SDS was born of this concern and formed on either the 30th or the 31st of July, 1968. Its principal purpose at this stage was to obtain and coordinate intelligence relating to the forthcoming October demonstration. Initially, the SDS gathered intelligence using a wide range of methods, of which undercover policing was but one. Very quickly, however, the SDS became a purely undercover police unit. It was and remained a part of Special Branch. The first recruits to the SDS were allocated to the unit by management and instructed to attend an initial meeting. Thereafter, recruitment was typically by way of a targeted approach to an existing Special Branch officer whom it was thought might make a good undercover officer. In its very early years, the SDS was predominantly, but not exclusively, male. 3 female officers served in the unit in 1968, and 2 more were recruited as UCOs in 1970 and 1971, respectively. After their deployments ended in 1973, SDS UCOs were all male throughout the remainder of the Tranche 1 era. In the period between its formation and the October demonstration, most of the groups infiltrated by the SDS were involved in preparations for that demonstration or were supportive of it. The depth to which the groups were infiltrated and the level of intrusion into the lives of individuals in 1968 was notably less than it was in later years. In some cases, there was not a great deal of difference between the traditional approach adopted by plain-clothed police officers and that of a very early SDS undercover officer. They concentrated on attending meetings, did not spend a great deal of time with their groups outside meetings, and slept in their real homes. What was different was a continuous use of a cover identity and a change of appearance, which enabled the officers to appear to be genuine activists. The result was greater access to private meetings and social events at which activists spoke more freely. SDS undercover officers sometimes entered the homes of activists and others in their undercover identities. This happened occasionally in the very early days of the SDS, but more frequently later. There is no evidence that the legality of doing so was given any consideration. The intelligence gathered by the SDS formed the basis of a series of reports produced by Chief Inspector Dixon and Detective Constable Roy Creamer. Their reports, which are in Chief Inspector Dixon's name, were fed up the chain of command. They must have helped to inform the Home Office. In the result, the main body of demonstrators marched without serious disorder on the 27th of October. The only serious trouble was occasioned by breakaway Maoist and anarchist demonstrators in Grosvenor Square. There is no doubt that in official circles, the SDS was credited with contributing to the successful outcome. There was even mention of undercover officers in the press. The Times lauded the Home Secretary's handling of the demonstration and attributed his success to intelligence received from the police. Special Branch received a letter of thanks from the American ambassador. Assessing the actual contribution of undercover policing to the outcome on the 27th of October 1968 is more difficult. The Vietnam Solidarity Campaign's leadership promoted a peaceful outcome. The breakaway group's intentions were well known. Special Branch had sources other than the SDS's undercover police officers. However, it might be said that the undercover officers' reports were timely, authoritative, and consequently provided further assurance to those planning the police response. They helped to avoid an overreaction. The perceived success of the SDS, combined with continuing concerns about forthcoming mass demonstrations, rapidly led to a decision to maintain the unit. Chief Inspector Dixon set out his vision for the unit's continued existence in a paper entitled Penetration of Extremist Groups. Of note are the respects in which his vision was not followed in practice. His advice that deployments should last no more than a year, and that undercover police officers must not take office within a group, chair meetings, or draft leaflets, was ignored. The Home Office played a pivotal role in the continued existence of the SDS. It funded cover accommodation for the SDS, which required periodic approval. From the financial year 1972-73 onwards, approval was granted for each financial year in response to a letter from a very senior officer, Commissioner Crime. From the outset, there was unease within the Home Office about the SDS. It feared embarrassing revelations. Ostensibly, the fact that the Home Office was funding the unit's unorthodox accommodation. Contemporary documents emanating from the Home Office repeatedly impressed upon senior police officers the need to ensure that the SDS's ongoing existence remained a secret. However, it was not until 1984 that anyone in the Home Office asked for more details and was then permitted to see a copy of an SDS annual report. One might infer from these facts that the Home Office was more concerned about the SDS remaining a secret than it was about precisely what the SDS was doing. Although the Home Office can rightly say that operational decisions are properly matters for the police, it is nevertheless striking that the Home Office was so uninquisitive about such sensitive operations. For example, Sir Hayden Phillips stated that, I quote, "All I recall was that my predecessor and immediate superior had taken the view that our role was to support the MPSB, and I authorized continued funding accordingly." That is a long way from the caution originally advocated by Sir James Waddell in 1968, who asked the MPS to keep the reasons for the SDS's existence under review, and did not think that the SDS should become a permanent feature of the branch. Home Office officials might have taken comfort from senior police officers who enthusiastically supported the SDS and referred to the unit in glowing terms whenever they sought continued funding from the Home Office. The evidence shows that senior officers visited the SDS periodically and received reports from the unit to inform successive bids for funding from the Home Office. These reports spelt out in some detail what the SDS had been doing and to what effect. They trumpeted the work of the SDS. We noted in the evidence on occasions a disconnect between the evidence of undercover officers and the terms in which managers represented their deployments in the annual reports. Further anti-Vietnam War demonstrations did not materialize on the same scale after October 1968. However, 1969 brought the unwelcome resumption of serious violence in Northern Ireland. There was also militant anti-apartheid protest, which included the use of direct action by the Stop the 70 Tour campaign in 1970. It fueled concerns that anti-apartheid was an issue that was likely to continue to generate large-scale protest. These two developments, together with other disturbances, were more than enough to persuade the Home Office and senior police officers of the continuing need for the SDS. It was also argued that the time taken for an undercover police officer to win the trust of some groups was such that infiltration had to be conducted proactively rather than reactively. In these circumstances, the SDS morphed after the October demonstration into something quite different from what it had originally been. The unit had been created to deal with a specific large-scale threat to public order. It had conducted numerous short-term, relatively shallow infiltrations broadly directed to gathering intelligence about that forthcoming demonstration. Officers had been given no specific training, and in some cases, no time to create a cover identity either. Early undercover officers deployed very rapidly when they joined the SDS. After the October demonstration, the SDS quickly became an undercover police unit which conducted long-term infiltrations of groups on the far left of the political spectrum. It continued to operate without providing its undercover police officers with any bespoke formal training. However, there was a trend towards officers spending longer and longer in the back office before deploying, time that was spent learning informally, becoming accustomed to the ways of the SDS and building an undercover identity. The size and management structure of the SDS varied only a little after the October demonstration. It was normally led by a detective chief inspector. He was supported by at least one, and sometimes as many as 3 detective inspectors. There was also always at least 1, and sometimes as many as 3 sergeants. Typically, one sergeant dealt with reporting, whilst another was responsible for other administrative matters. But the unit was so small that those of managerial rank sometimes discharged other tasks and covered for colleagues. The number of undercover officers varied a little, but was typically 12. A pattern begins to emerge, even during the Tranche 1 era, of former SDS undercover police officers returning to the unit to take up managerial posts. Early undercover officers HN 135 Mike Ferguson and HN 218 Barry Moss, who used the cover name Barry Morris, each went on to lead the SDS before the end of Tranche 1. We will be investigating the impact that former undercover officers who returned as managers had on the culture and practices within the unit as we progress through Tranches 2 and 3. There was no formal recruitment or selection process for undercover officers. Special branch officers were usually approached and interviewed. Some recruits describe having asked to join and then being considered. New undercover officers were mostly detective constables, although some were detective sergeants. It became the norm after the first few years for the SDS to recruit officers who were either married or in long-term intimate relationships. Almost all witnesses gave answers to the effect that a reason for this practice was to help anchor the officer to reality. Many also either stated or alluded to the fact that there was a belief that it would serve to discourage undercover officers from forming intimate relationships whilst in their undercover identities. We regard this as important early recognition that there was a risk of such relationships. A practice also developed by which managers would visit prospective undercover officers, often in their own homes, to meet their partners. It probably started in 1978 when HN 96, cover name Michael James, was recruited. Managers sought to assure themselves that the officer would have a supportive home environment and to give assurances to the officer's partner. SDS managers, like their undercover colleagues, received no bespoke training when they joined the SDS. It is tempting to attribute problems which occurred to the lack of bespoke training for all concerned, or a lack of regulatory oversight for that matter. But I refrain from doing so at this stage. These are issues which need to be investigated in future tranches before conclusions can be reached safely after consideration of all the evidence. We are keenly aware that in Tranche 4, we will be receiving evidence about a unit whose members had specific training and operated under the statutory framework imposed by the Regulation of Investigatory Powers Act 2000. Despite these developments, we know that deeply problematic activities continued. Explanations other than training and regulation need to be considered. For example, were there deep-seated cultural problems which proved to be impervious to both training and statutory regulation? Legend building by new undercover officers was initially rudimentary. The very earliest undercover officers deployed immediately. For example, HN 329, cover name John Graham, stated that he deployed, quote, straight away. Never had cover employment, but did rent a bedsit. Cover accommodation, cover employment, and changes to dress and appearance rapidly became the norm. Vehicles followed, with driving licenses in the officer's cover identity being normal in phase 2. However, in other respects, undercover identities remained superficial. Cover accommodation was typically a bedsit. Only 2 Tranche 1 officers shared cover accommodation. HN 106, cover name Barry Tompkins, and HN 96, cover name Michael James. SDS officers appear to have been given considerable latitude when constructing their undercover identities, such that HN 298, cover name Michael Scott, took the extraordinary step of adopting the name of a living adult. It is of particular concern that HN 298 later went on to be convicted in that name. Despite persistent efforts, we have not been able to trace the record of this conviction. A marked change occurred in the early to mid-70s. The practice of basing cover identities on at least some of the particulars of a deceased child was introduced. No written instructions about how to find and use a deceased child's identity or part thereof when constructing a cover legend have survived from this time, if they ever existed. However, the practice was certainly introduced. Almost all the subsequent SDS undercover officers in the Tranche 1 era adopted at least a part of the name of a deceased child. Some gave evidence that they conducted research in the location where the child in question had lived. For example, HN 304, cover name Graham Coates, made a detour to the location of his own volition. HN 96, cover name Michael James, stated that he had been instructed to visit Blackpool and was assisted by the local special branch to establish that Michael James's family no longer lived at their former address. However, in most cases, the evidence is that officers did no more than conduct research using the registers of births and deaths before selecting a deceased child for legend building purposes. There appears to have been no consistent practice as to the age at death of the child who should be selected. One school of thought was that a child who had died very young would leave much less evidence of their real life for anyone investigating the officer to find. The opposing school of thought was that death certificates of an older child would be much more time-consuming to find. Few researchers would be inclined to stick at the task for long enough to uncover the deception. At the heart of the rationale for adopting the name of a real individual was that it afforded protection at the material time from anyone who might decide to check whether the undercover officer had a real birth certificate. The register of births in those days was kept in hard copy, and entries were made in order in books. A person who did not adopt the identity of a deceased individual was vulnerable to a straightforward check of the register, which would give rise to a strong suspicion that they were not who they said they were. False entries could not be inserted into the records because they were compiled in order in hard copy. Even on a utilitarian analysis, there were strict limits to the level of additional protection that adopting a deceased child's identity would afford from hostile inquiry. Anyone persistent enough to search through the register of deaths might eventually find the child's death certificate. This is precisely the fate which befell HN 297 Richard Clark, cover name Rick Gibson, one of the earliest officers to use a deceased child's name. At a moral level, adopting the name of a deceased child is deeply problematic. Deceased children leave bereaved parents, siblings, and other loved ones. Typically, former members of the SDS appear to have taken the view that this did not matter because they believed that relatives would never find out. It is unclear precisely why the SDS adopted the practice of using aspects of deceased children's identities in the construction of cover legends. There had been no previous compromise of an SDS officer because he did not have a verifiable birth certificate. It is known that others, including the KGB, used the technique. It had also received wide publicity because of its use in the day of the jackal. We have not been able to establish who initially decided upon or authorized the SDS's use of the practice. We have received a variety of accounts about how decisions about targeting were made and by whom. They are not all reconcilable, and there does not appear to have been a single rigid approach. Individual UCOs recalled varying experiences. Some were tasked at the outset of their deployments quite specifically. Others were given much vaguer briefs based upon fields of activism or geographic areas. Most describe a process of discussion with and steering from their SDS managers. Two state that they were essentially left to their own devices. HN298, cover name Michael Scott, and HN299342, cover name David Hughes. Both these officers mixed with a significant number of different groups. The security service communicated either to special branch officers or direct to SDS managers those groups that it had an interest in, gaps in coverage that it wished to see filled, and on occasions some very specific intelligence requirements. For example, the security service on occasion made very specific requests for intelligence about the Socialist Workers' Party, the SWP. The security service did not decide how SDS UCOs were deployed, but its requirements as a major consumer of SDS intelligence were clearly influential. It was, for example, very interested in the Workers' Revolutionary Party, a party that was infiltrated by the SDS, despite it posing no public order threat and pursuing its revolutionary aims through the ballot box. Ultimately, responsibility for targeting remained with the police. The UCOs investigated in Tranche 1 infiltrated groups on the extreme left wing or which were suspected of being influenced by the extreme left wing. The most frequent targets were Trotskyist groups, particularly the International Socialists, who became the SWP in 1977, the International Marxist Group, and the Workers' Revolutionary Party. Maoist groups were also targeted, as were anarchists, anti-apartheid groups, groups campaigning about Ireland, and groups campaigning for race or sex equality. The evidence suggests that the groups infiltrated by the SDS were the kinds of groups that were of interest to Special Branch and which Special Branch would have gathered intelligence about with or without the SDS. More notable are those groups which were of interest to Special Branch and or the security service, but were not infiltrated by the SDS. In particular, the Communist Party of Great Britain and the extreme right wing. In both cases, it appears that the most likely reason is that there were alternative sources of intelligence available. In the case of the far right, there might also have been some reticence about the risks involved, although SDS managers did go so far as to make clear that the unit could if needed, infiltrate the far right. Moreover, the SDS did, in fact, go on to infiltrate the far right later. The groups infiltrated by the SDS were also, in the main, the kind of groups which featured in reports produced for the various counter-subversion committees, evidence of whose activities is contained in the documents adduced in our Module 2C investigation. The SDS was also reporting on public order issues that were of specific interest to the Home Office and the Cabinet Office. For example, the October demonstration at the start of the Tranche 1 era and the aftermath of the Brixton riots at the end of that period were both of particular interest to these departments. In other words, the work of the SDS went with the grain of concerns that were being discussed at the top of government. There are, though, limits to the extent to which the work of the SDS correlated with concerns within government. As I have already observed, the SDS did not target the Communist Party of Great Britain, the CPGB, and the intelligence which it provided in relation to subversion within industry was limited. This despite both the CPGB and industrial unrest being of real interest to the governments of the Tranche 1 era. A striking feature of SDS intelligence reports is the sheer breadth of intelligence gathered. Information about individuals and groups was hoovered up for later analysis without a great deal of filtering by the SDS. Some officers stated that they knew what to report based on previous experience with Special Branch. Many officers took the view that it was for others to decide what was relevant and what was not, because they, the UCOs, did not have the full picture. Consequently, they cast their nets wide. They were not told to do otherwise. They saw precedents whilst working in the back office before deploying. Their reports were signed off by managers, and their product was gratefully received by customers. In relation to individuals, more attention was paid to leaders and committed activists than to others. However, reporting was by no means limited to such people. Individual attendees at meetings are often listed in reports where they could be identified. Supporters and sympathizers of groups are sometimes mentioned as well as members. In some instances, people are identified in reports for no more than expressing interest in a group. A wide range of information was recorded about individuals where it could be obtained. For example, names, addresses, employment particulars, physical appearance, race, sexual orientation, intimate relationships, marital status, children, health issues, finances, and vehicle particulars, as well as political beliefs and political activities. The extent to which officers became involved in the lives of the activists upon whom they were reporting is striking. There are instances of UCOs attending weddings and of babysitting children. Reporting relating to children was not always ancillary to the activities of their parents. The political activities of teenagers were sometimes recorded independently. The security service had an interest in the efforts made by political groups on the extremes of the political spectrum to influence school-aged children and the activities of the youth wings of political parties which it considered to be subversive. The SDS serviced these intelligence requirements where it could do so. There were also fears that politicized teenagers posed a public disorder threat. As with other facets of the SDS's work, what it did in recording details about children was not out of kilter with wider special branch operations. For example, a registry file was opened on the core participant we refer to as Madeline in 1970, when she was 16 years old. The tone of SDS intelligence reports is, on many occasions, sarcastic or otherwise unprofessional. The attitudes betrayed by the language used in reports are significant. There is sexism. There is racism. There are many examples. Such reporting was known to managers and accepted because they signed off the reports. There appears to have been no anti-discrimination training for either officers or managers, despite the coming into force during this era of the Sex Discrimination Act 1975 and the Race Relations Act 1976. Sir, you will need to consider whether racism and/or sexism influence targeting, and in the case of justice campaigns, whether it influenced the deployment. That will involve considering not only the evidence of attitudes contained in the reporting, but in other written and oral evidence that you have heard. The same applies to the sexual activities of undercover police officers with members of the public in their cover identities. This may be an issue that you choose to wait to deal with in your final report, once we have the benefit of the full evidential picture for both the SDS and the NPOIU. Reports often centered upon how disorganized, divided, and ineffective groups were. Such observations serve to cast further doubt upon whether the people and groups reported on really were a sufficient threat either to public order or to parliamentary democracy as to justify deploying undercover police officers into their midst. Reporting on groups sought to build up as full a picture as possible of a given group's activities. Everything from a group's constitution, policies, literature, membership details, financial affairs, leadership, factions, interpersonal dynamics, aims, conferences, social events, meetings, demonstrations, and other political activities were reported upon. Very long and detailed reports on the proceedings at national conferences were common and often drew praise. We do not suggest that detailed professional reporting on a group or an individual by an undercover police officer is in principle wrong, but the threat posed by the group or individual must be sufficiently serious to justify such reporting on them. It is one thing to infiltrate an organized crime gang and report relevant intelligence. It is quite another to infiltrate a law-abiding political party or protest group, which is neither a threat to public order nor threatens the safety or well-being of the state. Securing a position as treasurer or membership secretary within a group was a route often taken by undercover officers. It afforded access to accurate and comprehensive intelligence about the group's financial and membership details. This practice was particularly common amongst, but not limited to, those officers who infiltrated the Socialist Workers' Party. Two UCOs, HN80, cover name Colin Clark, and HN 155, cover name Phil Cooper, secured access to the SWP's central office, where they obtained and reported much confidential information. HN 297, Richard Clark, rose through the ranks of the Troops Out movement, or TOM, becoming a branch secretary, regional organizer, and then convener of the Secretariat. The taking of offices of this nature was unusual, and many officers gave evidence to the effect that roles such as secretary were deliberately avoided because of the risk that the officer would become involved in decisions which would influence the direction of the group. Mr. Chesham gave important evidence about the influence which Richard Clark had in TOM and his effects within the group. There can be no doubt that managers were aware that UCOs were taking office within target groups. They signed off the reports which record their election to these officers. Having an undercover police officer assume an office within groups such as the SWP and TOM is deeply problematic, even more so where the role involves participating in decision-making on behalf of the group. We have not found evidence that elected politicians were specifically targeted. Elected politicians are sometimes mentioned in SDS intelligence reports. For example, prominent figures on the left of the Labour Party appear in reports from time to time. However, the references to them are usually incidental to reporting on extreme left-wing groups. Typically, politicians such as these are referred to in reports because they have spoken at events attended by the UCO's target group. Occasionally, there was closer contact, although it too was incidental to the targeting of an extreme left-wing group. Similarly, we have not found evidence that trade unions were specific SDS targets or that individual trade unionists were reported upon solely because of their trade union activities. However, trade unions and trade unionists are both mentioned in SDS reporting. There was a clear interest in the activities of members of extreme left-wing groups within trade unions, especially so when this was thought to be clandestine. The influence of extreme left-wing groups within trade unions was reported upon. One SDS undercover officer joined a trade union, the Transport and General Workers Union, to enhance his cover, HN 299342, cover name David Hughes. Specific justice campaigns often feature in SDS reporting. This tended to occur when an infiltrated group supported the campaign in question. For example, the reporting on the Shrewsbury 2 Action Committee and the Newham 8 Defence Campaign was ancillary to deployments into other groups. There is also reporting about protests against the police and the activities of police monitoring groups in the Tranche 1 era. As we discussed in our recent opening statement for Module 2B and Module 2C in the Tranche 1 era, there is evidence of a freestanding interest within the Metropolitan Police in gathering intelligence about campaigns which it considered to be anti-police and police monitoring groups. The Friends of Blair Peach campaign is an example of a justice campaign critical of the police, which was the subject of reporting by officers operating within sympathetic groups. Reporting continued despite evidence that the campaign was not causing public disorder. The sensitivity of the case did not prevent SDS attendance at the funeral. We have heard moving evidence from Celia Stubbs about the impact which these revelations have had upon her. The Women's Liberation Front, or WLF, was infiltrated by the SDS and existed specifically to champion sexual equality. However, it was a Maoist group and may have been targeted because it was Maoist. Similarly, most extreme left groups in the Tranche 1 era campaigned for sex equality, and they appear to have been infiltrated not because they did so, but because they were on the extreme left and considered to be either a threat to public order or subversive, or both. Nevertheless, it is striking that an undercover police officer was deployed into the very small WLF, which was campaigning for things, many of which are either required by law or considered entirely normal today. Particularly so when the WLF itself was not involved in criminality other than fly posting, posed no threat to parliamentary democracy, and was not a threat to public order. We submit that this deployment, which lasted for almost 2 years, is a particularly clear example of unjustified targeting. The aims and objectives of the WLF included equal rights for women, equal pay, equal opportunities in employment, education, training, social and political life, to fight against discrimination with regard to marriage, divorce, inheritance of property, taxation and insurance, and discrimination against children born in and out of wedlock, the right to contraception and abortion facilities, women's involvement in political and social activities, and to support the struggle of workers and oppressed people around the world. Reporting on campaigning for race equality arose in various ways. On occasion, the SDS specifically targeted groups which were single-issue groups. For example, the anti-apartheid movement and the Stop the 70 tour campaign. The anti-apartheid movement is another example of a particularly questionable target. The anti-apartheid movement did not have subversive aims. It also cooperated with the authorities when organizing and conducting demonstrations. Its demonstrations, although large, do not appear to have been a threat to public order. More frequently, officers reported on race-related activism having infiltrated extreme left-wing groups whose campaigning on race equality was but a part of the group's activity. The Socialist Workers' Party is but one of many examples of such groups. The deployment of HN 106, cover name Barry Tompkins, developed a significant focus on race-related campaigning. It started with a brief to find groups on the far left, other than the ones which the SDS already had well covered. HN 106 infiltrated a number of groups, including the Revolutionary Communist Group, through which, in its various manifestations, he became involved in the East London Workers Against Racism. It is a deployment which appears to have some similarities with the later deployment of HN 81, cover name David Hagan, who reported on the Stephen Lawrence campaign via the Movement for Justice in the 1990s. Occasionally, officers appear to have been steered mid-deployment to a race-related issue which was of concern. In particular, the SDS sought to gather intelligence in the aftermath of the Brixton riots. HN 356, cover name Bill Biggs, moved from South East London SWP to the newly formed Brixton SWP soon after the riots. There was, in general, little awareness of what legal professional privilege is amongst SDS undercover officers. Still less was there a recognition of the fundamental importance of legal professional privilege to the rule of law. On occasions, SDS undercover police officers became privy to legally privileged material and reported it back. It was not filtered out of the formal reports which were produced and filed. Consequently, we have found instances of privileged material being recorded in SDS intelligence reports. We have found no evidence to suggest that legally privileged material was specifically sought out by SDS officers or requested by its customers in the Tranche 1 era. However, procedures should have been in place to prevent the violations of legal professional privilege, which clearly occurred. Similarly, there appears to have been little awareness of the importance of protecting independent journalism. Again, protections should have been in place to prevent inappropriate reporting. Special Branch was the single largest consumer of SDS intelligence. Written SDS intelligence reports were usually filed by Special Branch, as well as being circulated to parts of the organization which it was felt needed to be aware of them. Once filed, they could be retrieved and used for various purposes. The most obvious purpose for which Special Branch appears to have used SDS intelligence was to inform reports which were made to assist the A8 branch to keep the peace. SDS intelligence played a role not just in relation to major demonstrations, but in relation to demonstrations, pickets, and other forms of protest of varying size. The role played by the SDS to assist with keeping the peace was not confined to written reports. Valuable real-time or near real-time intelligence was also telephoned in when it was too urgent to use the normal written channels of communication. For example, intelligence was telephoned in during the Battle of Lewisham. Another purpose for which SDS intelligence reports might have been relied upon by Special Branch was for vetting purposes. We cannot rule out that SDS intelligence reports were leaked by Special Branch officers to private sector organizations, which then used them for blacklisting purposes. The provision of intelligence of this sort to private sector organizations, such as the Economic League, was against regulations. However, as we have noted in previous submissions, there appears to have been some recognition that Special Branch officers were, in practice, likely to be tempted to do so. Information gathered by the SDS may also have been relied upon in Special Branch reports provided to government, especially the Home Office. It is also likely to have been used by R Squad, the research department, and other parts of Special Branch. Most SDS intelligence reports were copied to the Security Service. The provision of SDS intelligence to the Security Service appears to have occurred throughout the Tranche 1 era. The Security Service filed the SDS intelligence which it received. The Security Service appears to have considered SDS intelligence useful. It was monitoring most of the groups infiltrated by the SDS and had its own vetting function. It appears that SDS intelligence might, on occasions, have formed part of the body of evidence used by the Security Service to compile reports for at least some of the various counter-subversion committees which we considered in Tranche 1, Module 2C. There was a considerable overlap between the groups and individuals of interest to the Security Service and those of interest to Special Branch. The basis for the Security Service's interest was its duty to consider counter-subversion, whereas Special Branch's remit was based upon its duty to keep the Queen's peace, as it then was, and to assist the Security Service. Witness Z stated that as far as can be ascertained from surviving written records, there is no evidence that the Security Service passed on SDS intelligence to any third party outside government. On occasion, information appears to have been passed to the Security Service from the SDS orally. In the Tranche 1 era, this usually took place through meetings with SDS managers. Such meetings were more frequent towards the end of the Tranche 1 era. At least 2 SDS undercover officers met directly with the Security Service: HN 106, cover name Barry Tompkins, and HN 336, cover name Dick Epps. The fact that we have found so many intelligence reports from as long ago as the Tranche 1 era gives rise to questions about why they have been retained for so long and for what purpose. We suggest that this is an issue best pursued in future tranches and considered at the end of the evidential hearings. There is some evidence that the SDS played an evidential role in the detection and prosecution of crime, but it is limited. Early in the life of the SDS, HN 323, Sergeant Helen Crampton, was involved in the prosecution and conviction of a member of Black Power for incitement to riot. The case was regarded as important. The then Director of Public Prosecution considered it, as well as the Attorney General, who consulted the Home Secretary about it. The original intention was that evidential work should form a part of the SDS's work. In practice, the SDS quickly became and remained a purely intelligence gathering unit. We have found no other example in the Tranche 1 era of SDS undercover officers giving evidence for the prosecution as a result of SDS operations. There is evidence of SDS intelligence leading to the identification of suspects and their arrest. The 1978 annual report records the arrest of 2 anarchists wanted for conspiracy to cause explosions. The role of SDS undercover officers in court proceedings in their cover identities is a matter of concern. The foremost example is that of HN 298, cover name Michael Scott. He was convicted with others in the name of a real living person. He violated the legal professional privilege of his co-defendants. His real identity was not disclosed to the prosecution, nor was it disclosed to the court. Consequently, the court was misled and a miscarriage of justice occurred. The work of this inquiry has helped to put that right. The convictions of Christabel Gurney, Ernest Rodker, and Professor Jonathan Rosenhead were overturned last month. The SDS appears to have put the security of its operation over and above its duty to the court and the rule of law. The priority accorded to protecting the secrecy of the SDS's work is consistent with other evidence that we have received, including the visit which HN 45, cover name David Robertson, received from very senior officers, Vic Gilbert and Roland Watts, after his cover was blown. On his evidence, it was made clear to him that, should he ever need to explain himself, he was expected to pretend that he was acting on his own initiative. Sir, you will need to consider whether a further referral to the miscarriage of justice panel should be made arising from the evidence about the deployment of HN13, cover name Barry Loader. He was prosecuted twice in Barking and Lambeth magistrates' courts. On the first occasion, when he was tried with others, the documents record that the court was told that one of the defendants was an informant. However, Mr. Craft's evidence is that he informed the court that HN13 was an undercover police officer. On the second occasion, the documents indicate that the court was informed that HN13 was, quote, a valuable informant in the public order field. This is a level of information which falls short of confirming that the man before the court was really an undercover police officer acting in a false identity. His case was tried separately from that of 3 other activists, but all 4 were convicted. HN68, cover name Sean Lynch, was convicted in his cover identity together with 5 others for obstruction at Bow Street Magistrates Court in 1970, after they all entered guilty pleas. There is no evidence that the court was aware of HN68's real identity. There is also some evidence that HN68 may have been convicted of fly posting in his cover identity. HN339, cover name Stuart Goodman, was stopped by police on suspicion that he was driving with excess alcohol. He gave his real name, but thinks that he may have been prosecuted in his cover name after Chief Inspector Saunders informed the court who HN339 really was. Many Tranche 1 SDS officers participated in the commission of minor offences, typically fly posting or obstruction. Managers clearly regarded such offending as justified by the nature of the operations that the UCOs were participating in. One officer, HN298, cover name Michael Scott, committed a crime of violence by hitting an activist leader, Jerry Lawless. No action was taken either by Lawless or the SDS. There is uncontested evidence that 5 SDS Tranche 1 undercover police officers became involved in sexual activity with women who they met undercover. 2 of these 5 officers are known to have had sexual contact with more than one woman. Another ultimately married the activist with whom he began a relationship and had a child with her. The other sexual contact involved ranged from isolated encounters through friendships which became sexual to what appeared to Madeleine to be potentially the beginning of an intimate long-term relationship. The motives of the officers varied from case to case. Motives included sexual gratification, advancing or protecting a deployment, and in HN300's case, seemingly love. The deceived women were mostly, but not always, activists and members of target groups. 2 of the undercover officers have had to remain fully anonymous. In the case of HN302, we can consequently only say that he served in the 1970s. All the other deceiving officers served in the mid-1970s or later. The inquiry has heard oral evidence from the 3 surviving undercover officers who have admitted sexual activity in their undercover identities. We have heard evidence about the other 2 who are both deceased. We have also had the benefit of the accounts of 2 of the deceived women, whom we refer to by the pseudonyms Madeline and Mary. HN 300, cover name Jim Pickford, was married to his second wife and had children when he deployed as an undercover police officer. Real questions arise as to his suitability for the role based on the evidence of his contemporaries. He is described as having had an alcohol problem, being a philanderer who chased after women, and as a man who fell in love all over the place. HN 304, cover name Graham Coates, said in evidence that HN 300, I quote, could not be in the presence of a woman without trying it on. We are particularly grateful to HN 300's second wife and children, whose evidence confirms that HN 300 left his second wife to marry a woman whom he had met whilst operating as an undercover police officer. The fact that HN 300's third wife was heard referring to HN 300 in his cover name indicates that the relationship started whilst he was in that role. HN 300's second wife provided evidence that HN 300 went on to have a child with his third wife. She has also confirmed that HN 300's third marriage failed. We note that there appear to be at least some parallels between HN 300's case and that of HN 14, Jim Boyling, cover name Jim Sutton, whose actions some 20 years later we will be investigating in Tranche 3. Of some importance is the evidence of what was known within the SDS of HN 300's sexual conduct whilst deployed. It will be for you, sir, to decide who knew what and when, and I will not set out all of the relevant evidence here. I know that others are going to make more detailed submissions on this issue. It perhaps suffices to say that there is a very strong body of evidence to demonstrate that HN 300's reputation as a womanizer was well known within the SDS. Further, the evidence of a closed officer was to the effect that he told HN 244 Detective Inspector Angus McIntosh at least that HN 300 had fallen in love with an activist, enough to lead to HN 300's departure from the SDS. Although this specific evidence was not accepted by Mr. McIntosh in evidence, it is consistent with more general evidence from HN 304, cover name Graham Coates. HN 297, Richard Clark, is another officer who was the subject of unflattering evidence from his contemporaries. He was described, amongst other things, as a womanizer and a carnivore. There is evidence that he was involved in the sexual deceit of as many as 4 women. 2 of the women were active within South East London Troops Out movement. At least one of the other 2 was associated with Big Flame, the group that Clark was attempting to infiltrate when it was discovered that he was not who he said he was. It is particularly troubling that Richard Clark was deployed as a man with a carnivorous sexual appetite into a university setting. The more so because he was significantly older than most undergraduates. The risk of sexual misconduct was surely foreseeable. Richard Clark's motive may not have been limited to sexual gratification. Mary's impression was that HN 297 deceived her to bolster his cover. Whatever his motive, she was clear that there was absolutely no way that she would have consented to sex with him had she known that he was an undercover police officer. His actions understandably left her feeling used and invaded both by him and the state. There is clear evidence that Richard Clarke's colleagues knew something of his sexual activity with activists. He appears to have told them himself. Whether Clarke's managers knew is less clear. They deny it, which brings their evidence into conflict with that of HN 304, cover name Graham Coates. HN 354, Vince Harvey, cover name Vince Miller, admitted to sexual activity with 4 different women during his undercover work for the SDS. 2 of the women were not activists, and the sexual activity in these cases consisted of a one-night stand on his account. The 3rd woman was Madeline, and the 4th, like Madeline, was also a member of the SWP. Sir, there remained some differences of fact between Madeline and Vince Harvey that you will need to decide, although we note that Madeline's version of events benefits from corroboration. The corroborative evidence comprises of a near contemporary document and the evidence of Julia Pointer. Both tend to show that the sexual contact was not confined to a one-night stand, but occurred over time. Madeline puts a period at about 2 months. Mr. Harvey was the first undercover police officer who has admitted to having sex with a member of the public, whilst in his undercover identity, to give oral evidence to the inquiry. He accepted that what he did was wrong and that he did not think that Madeline would have consented to sex with him had she known that he was a police officer. He did not use contraception. He did not tell anyone because he did not attribute much importance to it. Madeline is the first deceived woman to give oral evidence to the inquiry. Vince Harvey's cover story had the effect of evincing sympathy from her. She feels betrayed, vulnerable, and disgusted. Sir, I have dealt with this evidence only briefly, conscious that advocates for both Madeline and Mr. Harvey will be addressing you in more detail in due course. HN 21 admitted to having become friendly with and then having sex with a woman who was not an activist. He had met the woman through an evening class which he was taking in his undercover identity. He stated that a lot of alcohol was involved on both his and her part. The encounter occurred on an evening when HN 21 was staying to protect her from the unwanted sexual advances of another man. HN 21 gave evidence that the pair remained close enough to have kissed and cuddled on a couple of further occasions, and then had sex again some 6 or 7 months after the first encounter. He does not know if the woman would have consented to sex if she had known who he really was. He used contraception. He accepted that what he did was wrong and unprofessional, but his guilt appeared to be focused more upon the fact that he was being unfaithful to his wife than the fact that he was a police officer on duty. He did not consider that at the time. He did not tell anyone about these events, which he regarded as a mistake. HN 302 gave evidence that he became friendly with a woman through attending meetings, which he was using to build up his cover. This took place over an extended period of perhaps 6 months. He socialized with her both in company and alone. They had sex after he invited her back to his bedsit. He used contraception. Although she had been involved in activism, he did not see her again after that. He said that he did not draw a distinction between a friendship and sexual activity because he was trying to live a parallel life and was trying not to be a police officer. He thought having sex might enhance his cover, but it didn't. He did not tell his managers because he thought it was part and parcel of living in his undercover identity. He does not think that he would have been given more than advice, that he had perhaps made a mistake had he informed his managers. We can see from these admitted sexual relationships alone that instances of sexual activity between undercover police officers in their cover identities and members of the public were not uncommon from the mid-70s onwards. In addition to the admitted cases, there is at least some evidence that a further 3 Tranche 1 undercover officers were involved in sexual activity with members of the public. In each of these cases, sir, you will need to evaluate the evidence and reach a conclusion. Mr. Neil Hardy volunteered information to the inquiry and later made a statement about HN 126, cover name Paul Gray. In his witness statement, Mr. Hardy states that he was an anti-Nazi League activist when he met HN 126. He gives his reasons for believing that there was a deceitful, intimate relationship between Paul Gray and a now deceased activist, Ros Gardner. There is evidence to corroborate the fact that at times Paul Gray and Ms. Gardner moved in the same circles during HN 126's deployment. The inquiry has afforded HN 126 the opportunity to respond to Mr. Hardy's allegation, which he categorically denies. The documents raise suspicions that HN 106 Barry Tompkins might have been involved in sexual activity with 2 different women. The evidence in relation to the first woman comes from a security service document made after a meeting with SDS management, which records that HN 106 had, quote, probably bedded the woman and been, quote, warned off by his managers. The evidence in relation to the second woman is that she is described in documents as, quote, Barry's girlfriend. HN 106 was too ill to give oral evidence, but has provided a witness statement in which he denies engaging in any sexual activity with activists. His explanation in relation to the second woman, whom he stated was not an activist, is that there was a close friendship which developed after her husband left her, and that sometimes he slept in her spare room. Finally, there is a case of HN 155, cover name Phil Cooper. The dispute of fact in this instance is whether he confessed to sexual activity in his cover identity to police risk assessors in 2017. Both risk assessors have given oral evidence to the inquiry to the effect that he did so, and stand by the written records of their dealings with HN 155. We have found no evidence of any positive management instruction in Tranche 1 that SDS undercover officers should engage in sexual activity with anyone undercover. Accordingly, the key questions on the evidence, we suggest, turn upon what managers did or did not know of the sexual activity that was occurring, whether managers did enough about such sexual activity as any of them were aware of, whether managers were aware of the risk of sexual misconduct, whether they did enough to prevent UCOs from engaging in sexual activity with members of the public in their false identities, and whether the actions of members of the SDS, both officers and managers, were affected by their attitudes to women. I shall leave detailed submissions to the core participants with the greatest interest in these issues. But as I have touched upon already, there is evidence of at least some management knowledge of some of the sexual activity that took place. There is also evidence that the risk of sexual misconduct was both obvious and recognized. More could and should have been done to reduce the risk of sexual misconduct by UCOs. There was no formal training. There is some evidence that advice was given not to participate in sexual activity, but it seems to have been haphazard. If you accept the evidence that managers had some knowledge of sexual activity, then the response to it was inadequate. A theme which we shall need to explore in later tranches is whether the absence of a disciplinary response was influenced by the prevailing culture, including attitudes to women and/or the desire to keep the activities of the SDS secret. The evidence of more than one SDS witness on the issue of sexual relationships was striking in that it focused upon the risk to the SDS, or the risk to the UCO, or the impact upon the UCO's real-life partner. The impact upon the member of the public with whom the UCO was engaging in sexual activity was either not a concern or not the first concern. Sir, I am aware that you are considering how far to go in dealing with the more thematic aspects of this part of the inquiry in your interim report, and what is best left for a decision once we have the benefit of all the evidence that the inquiry will hear about deceitful sexual activity. There is ample evidence that long-term undercover deployments of the kind that became the norm in the SDS were very stressful. There was a constant fear of being found out and of what the consequences would be were that to happen, plus the disorientating effect of leading two very different lives in parallel. The mental health of a striking number of officers was adversely affected by their work. Most officers were positive about the support which they received from their managers, but there was a lack of specialist support. There was also a lack of aftercare. This is an issue on which we will be hearing a lot more evidence in tranches 2 and 3. So too is the way in which the partners of SDS officers were treated. In tranche 1, 2 former heads of the SDS, HN 218 Barry Moss and HN 34 Jeffrey Kraft, accepted, with hindsight, that better care and attention could have been paid to them. The evidence shows that the existence of the SDS was well known to many senior police managers in the chain of command. They visited the unit, received its annual reports, and lobbied for continued funding from the Home Office, extolling the virtues of the unit as they did so. They are likely to have been aware in broad terms of what the SDS was and what it was doing, but less likely to have been aware of the details. The SDS must have been at least reasonably well known within Special Branch more generally, albeit shrouded with some mystery. This is so because Special Branch was a relatively small institution. Those who served in the SDS were recruited from within Special Branch and usually returned to its more conventional postings after their time with the SDS. The security service knew about the SDS from the latter's very inception, although the number of people within the security service who knew appears to have been deliberately limited to a select few. Conrad Dixon had a pre-existing working relationship with the security service before the SDS was established and met with members of the security service on the 2nd of August 1968, which was 2 or 3 days after the SDS was founded. The Security Service received most of the SDS's intelligence reports throughout Tranche 1, and from 1974 onwards filed SDS intelligence as such. The degree of direct personal contact that the Security Service had with the SDS varied over time, but was sometimes frequent. There was certainly some knowledge of the SDS within the Home Office. It received and approved requests for funding, and in 1970, the then Home Secretary was personally consulted about such funding. In 1984, Mr. Harrington was permitted to inspect and make notes on the SDS's 1983 annual report. We have dealt at some length in our Tranche 1 Phase 3 and Tranche 1 Module 2B and 2C opening statements with Home Office documents about the role of Special Branch assisting the Security Service with counter-subversion work. Some of the officials involved in those conversations knew of the existence of the SDS. The concerns raised within the Home Office in the late 1970s and early 1980s about Special Branch's role in counter-subversion were apposite. I invite you, sir, to consider whether an opportunity relevant to the SDS was missed when those concerns were not acted upon. In particular, insofar as they relate to persons who were acting lawfully and were not threatening either the safety or well-being of the state. The result of much debate emerged in 1984 in the form of the Home Office guidelines on the work of a special branch and accompanying confidential letter. These documents continued to permit counter-subversion work to be carried out by Special Branch, including the SDS, against people who were obeying the law and only potentially subversive. It is likely that knowledge of the existence of the SDS was disseminated within some of the high-level counter-subversion committees discussed in our recent opening statement for Module 2B and Module 2C in the Tranche 1 era by those on the committees who knew about the SDS. The membership of these committees included representatives from various parts of government, but with an emphasis on the Home Office and the Cabinet Office. By way of examples, the Subversion at Home Committee, chaired by the then Cabinet Secretary, Sir Burke Trend, appears from the cryptic contents of its January 1969 minutes to have been aware of the existence of the SDS. Deputy Assistant Commissioner Vic Gilbert sat on the Subversion in Public Life Committee. He had had direct contact with the SDS because he is one of the senior officers who HN 45, cover name David Robertson, stated spoke to him after he was compromised. The primary stated purpose of the SDS was to provide intelligence for public order purposes. There can be no doubt that the SDS did that. Its UCOs provided intelligence before, during, and after demonstrations and other forms of protest. Intelligence provided in advance of demonstrations as to likely numbers, demeanor, and other matters no doubt assisted those charged with policing public order to calibrate the police response. In some cases, SDS intelligence would simply corroborate other sources. In other instances, particularly in relation to secretive groups which did not cooperate with the police, other sources will usually have been fewer and potentially less reliable. Intelligence during events must have helped police on the ground. Other forms of assistance, such as identifying hotheads or offenders from photographs, had value. However, it is hard to identify a single instance in which SDS intelligence averted a public order calamity in the Tranche 1 era. Without the SDS, the police would still have had all their other sources available to them. I do not propose to conduct a systematic analysis of every group infiltrated by the SDS, but the threat to public order posed by different groups differed widely, both between groups and over time. The evidence from UCOs about some groups was to the effect that the group was not a public order threat at all. I have already mentioned the anti-apartheid movement, Women's Liberation Front, and Workers' Revolutionary Party in that regard. Sometimes the public order justification offered was the fear that a group might become a public order threat. Other groups were involved in public disorder, notably the International Socialists, who became the Socialist Workers' Party and grew considerably in size during the Tranche 1 era. The International Marxist Group, although small, could provoke trouble out of all proportion to its size, as events at Red Lion Square show. Some Maoists and some activists could do the same. The Stop the 70 campaign was not violent, but it was uncooperative with police and used direct action to further its aims. There were times which were particularly febrile from a public order perspective, the autumn of 1968 principally amongst them. The peaks of tension between the far left and the far right, especially but not limited to 1977, were also challenging for police. But there were other times when things were quieter. The utility of SDS intelligence for public order purposes is only one part of the equation. The level of intrusion into people's lives arising from SDS operations, particularly once long-term deployments became the norm, was very considerable. Moreover, the intrusion resulting from the SDS's operations was into very sensitive areas of people's lives, their political lives, their financial affairs, their legal affairs, their families, their friendships, and even, in some instances, their sex lives. Operations were not limited to times of heightened risk, nor confined to the shadow paddling of the earliest SDS undercover officers. They were long-term and highly intrusive operations conducted continuously. In these circumstances, we submit that the need for and value of the public order intelligence provided by the SDS was not an adequate justification for the intrusion caused by the SDS model of long-term undercover policing in the Tranche 1 era. The SDS's ancillary purpose was to assist the security service to defend the realm against subversion. The principal difficulty that we have with what occurred is quite simply stated. The groups infiltrated were not subversive. They do not meet the Harris definition, which was adopted by the Security Service in 1972 and made public in 1975. Most, although not all, wished to overthrow parliamentary democracy. However, on the evidence that we have received, they did not threaten the safety or well-being of the state, a definition that uses the present tense. None were anywhere close to toppling multi-party democracy. none had international backing of the kind enjoyed by the CPGB. Some fanned the flames of industrial unrest, although that activity was not the focus of SDS reporting. Some organized demonstrations or counter-demonstrations which were violent. Insofar as they did either of these things, though, they could not be said to have threatened the well-being of the state. Or, if we are wrong about that, and they did so, then the scale and duration of any such threat was not serious enough to justify the level of intrusion that in fact occurred. Personal information recorded by SDS officers may have been used when files were later interrogated for vetting purposes. However, vetting occurred both before and after the SDS's existence. The level of intrusion into people's lives occasioned by SDS infiltrations does not seem to justify, does not seem to be justified by any additional relevant data that the SDS might have collected. It is certainly not a purpose which features prominently in the documents. There is no evidence that anyone took legal advice about or considered the legality of the methods that the SDS was using. Someone should have done so. Had they considered domestic law, there would have been areas of concern which should have prompted at least relevant training and supervision, especially in relation to trespass to property and the taking of confidential information. Some of the circumstances in which SDS UCOs obtained access to private homes and took confidential information appear to have been of doubtful legality. The threat to public order or to national security, if it existed at all, appears simply not great or immediate enough to amount to a defense. There was no statutory framework for undercover policing during the Tranche 1 era, nor was there any system of judicial oversight. A statutory framework was only introduced in 2000, very shortly after the Human Rights Act 1998 came into force. In the absence of a statutory framework, it is highly questionable whether the United Kingdom was compliant with its international law obligations under Article 8 of the European Convention on Human Rights at any point during the Tranche 1 era in relation to the undercover policing conducted by the SDS. How important that observation is to the work of this inquiry in Tranche 1 is perhaps another matter. The much bigger questions, I suggest, in relation to statutory frameworks is why things continued to go wrong after the introduction of the Regulation of Investigatory Powers Act 2000, and whether the current statutory framework is adequate. Those are questions for later tranches. Since I am touching upon legal issues, this is a convenient place at which to say a little about the core participants' written closing statements. We are grateful for the submissions received and the considerable thought and industry which they reflect. However, the submissions made by the teams led by Mr. Scobie, King's Counsel, Mr. Menon, King's Counsel, Ms. Heaven, and Mr. Sanders, King's Counsel, urge you to impugn the evidence given to the Home Affairs Select Committee and/or accuse politicians of misleading Parliament. Parliamentary privilege prevents you, sir, from entertaining any such submissions. Such issues are a matter for Parliament alone. There is also mention in some submissions of case and the burden of proof. This inquiry is being run on an inquisitorial basis. there is no question of deciding between competing cases or imposing a burden of proof upon any participant. I turn finally to some concluding remarks. The SDS was created in 1968 to deal with a specific large-scale public order threat, for which there was a concrete basis for concern. It used relatively short and shallow deployments to gather valuable intelligence about the October 1968 demonstration. The unit then became a permanent feature, deploying undercover officers continuously into far-left groups, often with vague remits. Individual deployments, which lasted for several years, became the norm. Officers became involved in the lives of those they were spying on. Although they were not ordered or encouraged to do so, in some instances, this went as far as sex. Reporting was extensive, unfiltered, deeply personal, and often recorded in unprofessional terms. We cannot rule out that some of it, once filed, was leaked to the private sector and misused to blacklist activists. The whole operation was secret, and a very high priority was accorded to keeping it that way. Courts were sometimes misled. Miscarriages of justice occurred as a result. An officer whose cover was compromised was told to pretend that he was acting independently. Discipline was not enforced. Aspects of deceased children's identities were used, even though they added only a limited further protection. These operations have caused a lot of harm. Democratic freedoms have been infringed. Outrage and pain has been caused. The damage is not limited to members of the public. Former undercover officers have suffered psychiatric injury. The primary reason for conducting these operations was to gain intelligence to assist police to maintain order on the streets. However, the level of threat posed to public order was often not commensurate with a need to deploy undercover police officers for this purpose, not in the way that they operated. The benefits which the unit's intelligence brought to public order policing do not, in our submission, justify the means. The ancillary reason for the SDS's work was to assist the security service to counter subversion. However, the evidence of the SDS's own officers and other contemporary documents show that the groups targeted by the SDS did not meet the official definition of subversion. Many of those targeted were revolutionaries, but they did not threaten the safety or well-being of the state. In the words of Commissioner of Police for the Metropolis, Sir Robert Mark, they were a bad joke. There was a remarkable lack of oversight, formal training, and instruction. However, the SDS was not a rogue unit. It was part of a larger intelligence gathering apparatus and counter-subversion effort, which also operated in secrecy. The SDS was known to the chain of command within the Metropolitan Police Service. Senior officers visited the unit on occasion and met its undercover officers. They received annual reports about the unit's work. The existence of the SDS was known to some within the Security Service, the Home Office, and to a lesser extent, the Cabinet Office. We remain of the view expressed in last month's submissions. There was no effective review of the SDS's operation. no one appears to have considered whether the level of intrusion occasioned by the SDS long-term undercover police deployments was justified. No one appears to have addressed their mind specifically to the legality of SDS operations. No one appears to have considered whether, after its introduction, both limbs of the Harris definition were met. There is a strong case for concluding that, had they done so, they should have decided to disband the SDS.
Thank you very much, Mr. Barr. We will resume, I think, shortly after midday with Mr. Skelton for the CL team. Thank you. Yes. Mr. Skelton, I'm not entirely sure that the device is fully operational yet. I'll pause while it becomes so.
Thank you, sir.
It is now. Mr. Skelton, now's the time for your closing submissions on behalf of the Metropolitan Police Commissioner. My understanding is that you're going to take a little over an hour. If you think it's sensible, take a break when you wish to, so it fits in more or less so everyone can have a convenient lunch.
Thank you, sir.
Thank you.
So in its written closing statement and in this oral statement, the MPS endeavours to draw conclusions from a detailed analysis of the evidence so far obtained by the inquiry in Tranche 1, which covers the formation of the SDS in 1968 and its operations until 1982. In doing so, the MPS doesn't shirk from accepting that certain conduct by the SDS and its officers was indefensible. However, it also seeks to judge the SDS fairly by reference to the wider socio-political, legal and policing context in which the SDS did its work, but also with the benefit of a modern perspective, recognizing that some of the values of the past may have been wrong and should have been known to be wrong at the time. In doing so, sir, the MPS seeks to draw a distinction between matters that have been thoroughly investigated in Tranche 1 and in respect of which findings may safely be made at this stage, matters that have not yet been investigated or investigated fully, where the inquiry may wish to defer making findings until a later point in its work, matters in respect of which it would be unfair to speculate or draw firm conclusions because of the passage of time and the non-availability of relevant evidence, and matters that are outside the inquiry's terms of reference or lawful remit. So this oral opening is not a repetition of the MPS's written closing statement and its appendices, but it will cover the same themes, and in places it will repeat what has been written. I'm going to cover the following general topics: sexual relationships, institutional sexism and misogyny, the legal framework, the responsibilities of the police, the historical context, and justification and value. And then I will make some remarks on a few discrete topics: training, personal reporting and language, criminality, and the use of deceased children's identities, before making some very short concluding remarks. So the first of those topics, sir, is sexual relationships. I would like to address this at the outset because it's so important and because it resonates with public perception of the MPS and the conduct of its officers in the present day. During the T1 period, 1968 to 1982, SDS officers had sexual relationships with women with whom they had contact while deployed. The MPS said at the opening of the inquiry's evidential hearings in 2020, and repeats now, those relationships were unacceptable and wrong. They should not have happened, and they have caused and continue to cause immense hurt and suffering. During this tranche, the MPS has read and listened to and wishes to make clear that it accepts the evidence of Madeline and Mary, who gave evidence to the inquiry about the relationships they had with undercover officers and the effects these have had on them. The MPS reiterates its unreserved apology to them and to the other women with whom undercover officers had sexual relationships. So it's not possible to determine at this remove precisely how many UCOs had sexual relationships during this period, or the identities of all of the women involved. The available evidence indicates that it was a small minority of UCOs who served in the SDS during this period, although this doesn't detract in any way from the wholly objectionable conduct that did occur. And most SDS officers maintained the professionalism and personal integrity that was to be expected of police officers in their position, and knew that they should do so. Several STS officers expressed a clear view in their evidence to this inquiry that this type of conduct was wrong, and this would have been well understood at the time, or should have been. Nevertheless, the deployment of male police officers into groups in which they had regular and in most cases long-term contact with women created a clear risk that, left unchecked, some officers would start sexual relationships with those women. And that risk, together with the unacceptable nature of such conduct, should have been fully and openly recognised by the STS's managers. So too should the consequential risk that any sexual relationships could have a grave impact on the women concerned, none of whom, it can be safely assumed, would have wanted to have any form of sexual contact with an undercover police officer. So the STS's managers should have taken robust and effective measures to prevent sexual relationships from occurring, and specifically they should have made clear to the UCOs in formal, explicit instructions and training that such relationships were prohibited, and absent an exceptional excuse such as the need to prevent otherwise imminent loss of life, would amount to serious professional misconduct. The MPS again apologises unequivocally for the fact that none of this happened. The evidence adduced by the inquiry doesn't indicate that the STS's managers in the T1 period authorised or encouraged UCOs to engage in sexual relationships, to improve their cover, or to further efforts to gather intelligence. However, there is some evidence suggesting that some managers may have been aware that sexual relationships were occurring, or were in possession of sufficient information to appreciate a risk that they were, and gave informal guidance that such relationships should be avoided. This knowledge has been denied by the few managers who are still alive and are in a position to give evidence in response. So, faced with these conflicting and incomplete accounts from a few elderly witnesses who are drawing on memories that are over 40 to 50 years old, the inquiry may consider that it's no longer possible or fair to make reliable findings as to what was known or was not known or said by individual STS managers at the time. However, for the avoidance of doubt, the MPS's position is that whatever the STS managers in fact suspected, knew or said at the time, they failed to take effective steps to stop relationships from happening. So I'm now going to say a few words about institutional sexism and misogyny. As its lists of issues make clear, the inquiry is actively investigating the important question of whether the actions of STS officers and the STS managers were affected by sexism. In their closing statements, the Category H non-state core participants argue powerfully that you should look beyond undercover policing and consider the wider culture and practice in the MPS in the 1970s and thereafter, with a view to identifying more pervasive sexism and misogyny. These submissions, of course, resonate in the present day, when trust and confidence in policing has continued to be undermined by the appalling criminal acts and behaviour of MPS officers in a series of high-profile cases involving misconduct towards women. The MPS has no wish to resist the investigation of this issue or any conclusions that may justifiably result. However, if the inquiry chooses to investigate it, then the process by which it does so should be thorough, open, and fair. So the inquiry will need to conduct its own investigation, not simply rely on the findings of others. And this may include consideration of the evidence adduced in subsequent tranches in which sexual relationships and the mismanagement of officers' conduct are likely to feature to an even greater extent than they have done in Tranche 1. It may also include consideration of the 1983 Police in Action report by the Policy Studies Institute, as well as other potentially relevant reports and papers, some of which have been referred to in the closing statements for this tranche. But for present purposes, sir, the MPS's position is that it would not be appropriate to make generalised findings about policing culture and practice unless and until that work has been done. I turn now to the legal framework. Sir, a neutral observer reading the closing statements made to you at the conclusion of Tranche 1 might be forgiven for thinking that the STS is on trial in a court not under investigation by an inquiry. Such is the level of legal argument and the volume of case law that is now being put before you. I will not add unnecessarily to that misapprehension today, not least because you've already had the MPS's detailed written submissions. But given the importance of the question of how the inquiry can and should approach its assessment of the legal framework, I'll try and summarize the key points that the MPS has made in its written closing statement. First, the terms of reference, which are the starting point. These require the inquiry to identify and assess the adequacy of the statutory, policy, and judicial regulation of undercover policing. They do not, as has been suggested by your counsel, require the inquiry to determine, in quotes, whether undercover policing was conducted lawfully, the legality of tactics, or the lawfulness of undercover policing as it was carried out by the SDS. Instead, their focus is on the nature and adequacy of the ways in which undercover policing was authorised, regulated and governed over time by the primary and secondary legislation, government policies, policing policies and the judiciary. As is well known, in the T1 era, this framework was for the most part non-existent or underdeveloped. In particular, there was no legislation to govern undercover policing, which wasn't introduced until the enactment of the Regulation of Investigatory Powers Act, RIPA, in 2000, Part 2 of which provided for the authorization of covert human intelligence sources, or CHIS. A point which I will repeat today, sir, is that you may wish to investigate why, for many years, the government didn't consider it necessary or helpful to introduce the kind of legislation that was needed for the regulation of all undercover deployments by the police in this country, not just those by the SDS. Second, Section 2 of the Inquiries Act, 2005. Public inquiries find facts and in many cases make recommendations. Unlike courts, they do not make the law or produce judgments that determine civil or criminal rights. However, their findings may need to be underpinned explicitly or implicitly by legal standards, such as what is permissible in terms of the use of force by a state agent. In such cases, inquiries are not making the law, but rather identifying the law as it is known to apply to certain activities. The prohibition in Section 2 of the Act, together with the explanatory note, reflect this important and nuanced position. So far as the MPS is aware, the domestic civil courts have never determined any cases in which allegations of trespass to property, breach of confidence, or breach of human rights prior to the 2nd of October 2000 have been levelled against UCOs. And the criminal courts have never determined any cases in which UCOs have been accused of burglary arising from their work. So determination of the legality of the SDS's work would therefore require the inquiry to assume wrongly the judicial function of a court. None of the public inquiries cited in counsel to the inquiry's legal framework submissions have taken such an approach. To do so in this inquiry would breach Section 2 of the Act. Third, principles of fairness and reasonableness. In the absence of a court, a judgment determining definitively that the SDS's operations or aspects of them were unlawful under the civil or criminal law as it applied in the period 1968 to 1982, it would also be unfair and unreasonable for the inquiry to make such a determination for itself. A finding of unlawfulness could only be made, as it would by a court, by examination of the facts in a specific case, i.e. particular occasions when UCOs entered the private property of an activist on which he or she was gathering intelligence, and this has not occurred. Even if it did occur, the exercise wouldn't be a reasonable or fair one in the context of the inquiry's inquisitorial proceedings. In a civil or criminal trial, the commissioner and the officers concerned would be entitled to basic procedural safeguards, such as the right to call their own witnesses, which don't apply in a public inquiry. Findings of illegality in respect to the T1 era would also not be reasonable or fair unless, before reaching them, the inquiry had given careful, explicit consideration to the question of whether such findings could safely be made 40 to 50 years after the index events. As the MPS said in its first opening statement for Tranche 1, the immense passage of time means that the inquiry is deprived of the evidence of many key witnesses, senior officers, politicians, civil servants, and intelligence officers, and many relevant documents. To quote what was there said, In some cases, it may be clear what is missing, and it may be that reliable inferences can be drawn from what remains or what those lost documents might have contained, but that may not always be the case. The inquiry and its participants may be wholly unaware that significant relevant evidence once existed, but has now been lost, and erroneous conclusions might be unwittingly and unfairly drawn as a result. So you have seen the MPS's submissions on the 4 legal allegations that have been considered by your counsel: trespass to property, burglary, breach of confidence, and breach of Article 8 of the European Convention on Human Rights. Beyond repeating that each of those allegations would need to be considered on the facts of a specific case, I will not restate what is said about the first 3 issues, but I would like to say something about Article 8, because consideration of it has wider implications for the inquiry's work. The Convention, like the English common law, is a living instrument which both responds to and influences the individual and collective values and mores of the societies it serves, together with their governments. It is possible to identify and chart how in the late and mid to late 1970s, the Strasbourg Court, and in the early days the European Commission, developed the principles that now underpin consideration of Article 8, the right to respect for private and family life. These include consideration of the requirement for necessity by reference to the concept of pressing social needs, the requirement for interferences in Article 8 rights to have some basis in domestic law, and for that law to be accessible and foreseeable. And more specifically, in the context of secret surveillance by a state of its citizens, the need for procedural safeguards, such as independent, preferably judicial, oversight. However, for much of the T1 period, these principles simply didn't form part of English law. And this is exemplified by the case of Malone, in which the English High Court declined to find that the UK's communications interception regime was unlawful. But a few years later, the European Commission and Strasbourg Court took a different view, a finding which was rectified, ultimately, by the enactment of the Interception of Communications Act 1985, which came into force the next year. The more difficult task is to chart the evolution of human rights law in the UK and Strasbourg, than to chart the evolution of human rights law in the UK and Strasbourg, is that of identifying what the values and mores, or to use Strasbourg terminology, the pressing social needs of UK society in the 1960s and 1970s were, and how they've evolved over the last 50 years. This task has not been undertaken by the inquiry as yet, and would require a very different kind of evidence from that which has so far been obtained. In the context of Article 8, what the inquiry can more readily do, in fulfillment of its terms of reference, is to identify that there was no statutory framework, no common law framework, and no procedural safeguards for undercover policing during the T1 era. It may be thought that the various governments of the time either didn't consider this absence to be problematic, legally or morally, just as they hadn't in respect of the interception of communications regime, or that they didn't consider it necessary or expedient to do anything about it. That, sir, is a question only the Home Office can answer. In any event, there are many reasons why the inquiry might conclude that this state of affairs was unsatisfactory, without recourse to the retrospective application of human rights laws that were not part of English law at the time. So during the T1 P3 opening statements, you put to me that on the whole, my understanding is that the police forces of this country have always sought to operate within the civil law, hence the need for warrants to perform acts that would amount to a breach of the civil law, and you invited submissions on this issue. The MPS's position in summary is that the police, like other agents of the state, should act within the confines of civil, criminal, and public law. To do otherwise would undermine the rule of law, and as a consequence, the principle of policing by consent, which will only be given by the public if the police are seen to act lawfully. The courts of England and Wales have, however, recognised that in some limited circumstances, the police and other state agencies do go beyond the boundaries of the law in pursuit of law enforcement and national security objectives. The MPS's written closing statement referred to several cases in which the courts, applying the public policies that underpin the execution of the law, including the wider public interest and the principle of proportionality, have declined to censure certain authorized activities of the state which would otherwise be unlawful. So why this is the case and whether it is acceptable are moral and political, not just legal questions, which require more careful consideration by the inquiry and its core participants than can be afforded in these closing statements in this tranche. The next topic I would like to cover is the responsibilities of the police, in particular public order and subversion. First, public order. The principal role of the police, as has long been recognised, is the maintenance of the Queen or King's peace, i.e. public order. However, the maintenance of public order or public tranquility must always be balanced against the basic democratic right to demonstrate and protest. The tension in policing terms is in ensuring a fair balance between individual rights and the general interests of the community. What is considered an appropriate or acceptable policing response to public order differs in different countries. The evidence in the T1 period shows that there was a real concern at the highest level about maintaining a traditional British policing response to public order. In other words, a response that minimized confrontation and the use of force by the police. For that model of policing to work, it required, and indeed still requires, as much advance information as possible about the event in question, so that the level of policing is commensurate with the task and neither provokes nor fails to prevent disorder and its escalation into serious violence. That is why the work of the MPSB was so, or special branch, was so important to public order policing, all the more so in an era when political protest was instrumental to so much public disorder. The second issue is subversion. The 1970 ACPO terms of reference for special branch stated that its officers were responsible to their chief officers and their function was to acquire security intelligence, both secret and overt, A, to assist the chief officer in the preservation of public order, and B, as directed by the chief officer, to assist the security service in the task of defending the realm from attempts at espionage and sabotage and from the actions of persons and organizations which may be judged to be subversive of the security of the state. The wording of the second of special branch's responsibilities, of course, echoed that of the directive given by the Home Secretary, Sir David Maxwell Fyfe, to the Director General of the Security Service in 1952, 7 years after the end of the Second World War. The 1970s terms of reference were applicable to the work of all special branches, including MPSB and the STS as part of MPSB throughout the T1 era. They were not replaced until 1984, when the Home Office produced its guidelines on the work of special branch, which also emphasised the responsibility of special branch officers and their two primary tasks of gathering information about threats to public order and assisting the security service. As your council have pointed out, the 1984 guidelines incorporated the subsequent definition of subversion given by Lord Harris of Greenwich, Minister of State at the Home Office, to the House of Lords in 1975, which itself derived from an internal security service definition dating back to 1972. Under the Harris definition, to be considered subversive, the activities in question needed to satisfy two limbs, that is, to be one, generally regarded as threatening the safety or well-being of the state, and two, intended to undermine or overthrow parliamentary democracy by political, industrial, or violent means. However, Lord Harris didn't elaborate, it may be thought deliberately, on precisely what kind of conduct would satisfy the first limb of the definition, i.e. what kind of conduct would constitute the requisite threat. The Home Office guidelines in 1984 were accompanied by a confidential covering letter, which is significant for the width of its interpretation, or arguably application, of Special Branch's second function, to gather information on potentially subversive organisations or individuals, even if they were currently acting lawfully. From one perspective, sir, it may be thought unethical and anti-democratic for the government to take such an approach to the activities of its citizens, or at least it could be in respect of those individuals and groups who in fact have no real capacity to threaten the state. But from another perspective, it may be thought sensible to take a precautionary approach to questions of national security and to monitor certain groups of people before they become actively dangerous, i.e., before it is too late to stop them. Prior to and throughout the T1 period, the Security Service saw itself and was seen by government as the only state body competent to determine whether a group was or wasn't subversive. That is why the service, not Special Branch, produced the overarching papers on subversion for the Cabinet Office throughout the T1 period and routinely advised the government on subversion via formal channels, such as the various committees on subversion, which you have seen, and directly by meetings between the Director General, the Prime Minister, senior cabinet ministers, and senior civil servants. Special Branch's function was to gather intelligence on subversion for the Security Service, not to analyze it. The service's function was both to gather intelligence and to assess it, which it did based on the entirety of the government's intelligence gathering apparatus, including its own intelligence and that produced by Special Branch and the SDS. It was therefore necessary for Special Branch to consult with and defer to the Security Service on the critical question of what constituted subversion and which individual groups met that definition. That process of consultation and advice is referred to directly by the Home Office in its confidential covering letter for the 1984 guidelines to which I've referred. It was not, therefore, constitutionally appropriate, necessary, or practical for the NPS to challenge the Security Service's assessments on those matters. In their statements to you, counsel to the inquiry have advanced a narrow interpretation of the Harris definition of subversion, which they submit should have been applied by Special Branch, and which, if it had been, should have led the police to conclude that it was wrong to use undercover police officers to monitor the activities of left-wing activist groups, particularly the ones that the SDS infiltrated. So such a legalistic approach is wrong in principle. It also doesn't do justice to the evidence that the inquiry has obtained, particularly from the Cabinet Office, which indicates that the groups that the SDS monitored in the 1970s were perceived to be subversive by the government and the Security Service, and so legitimate targets for close monitoring by the state's intelligence apparatus, of which the SDS was but one part. If the inquiry does wish to make high-level generalized findings of this nature, it will need to conduct a more detailed investigation of the issue of how subversion was viewed in this period, and to interrogate more carefully the working relationships between the Cabinet Office, the Home Office, the Security Service, and Special Branch, topics which I've already touched on. I turn now to the historical and socio-political context in which the SDS did its work. The inquiry is aware that the SDS was formed in late July 1968, comprising a small group of officers under the supervision of Detective Chief Inspector Conrad Dixon, with instructions to ascertain what information they could about the upcoming Vietnam Solidarity Campaign, or VSC, demonstration scheduled to take place in central London in October 1968. However, the SDS was only one element of a wider policing response to large-scale public disorder, and so it's essential to place it in its historical, political, and policing context. In each of the NPS's opening statements during Tranche 1, it has emphasised the importance of the inquiry obtaining neutral, independent evidence from an expert historian, so that the work of the SDS can be properly contextualised and understood in this way. In the absence of such evidence, it now falls to the NPS and other core participants to provide their own versions of what they judge to be the relevant historical context, with the inevitable, if unwelcome, consequence that those versions will be criticised and dismissed as partisan and incomplete. Nevertheless, the exercise is an important one. The NPS's written closing statement therefore contains an account of some of the key events that bear upon the formation and function of the SDS during the T1 period. I won't repeat that summary today, but you will see that particular attention is given to the year 1968, including the 17th of March demonstration against the war, the Vietnam War, concerns about public disorder, concerns about subversion, the formation of the SDS, and the October 1968 demonstration, and then the aftermath of that demonstration, including the involvement of the Cabinet Office and the Home Office, and the Home Secretary's comments to Parliament on the 7th of November 1968, during which he said, and I quote, "There are groups of people who go under the name of Maoists, anarchists, Trotskyites, and half a dozen other small factions who are determined to provoke trouble with established authority, mostly in the person of the police, on any occasion when they can find suitable excuse for so doing. I have no sympathy with these people, nor have the overwhelming number of people in the country. A careful watch must be kept on any intentions that they may have." Attention is also given in the MPS's written closing statement to the Home Office's authorizations of the STS's work, which was much more than approval for funding of officers' accommodation, as counsel to the inquiry have implied. The contemporaneous documents indicate quite clearly that the Home Office was fully aware of the nature of the STS's work and expressed no legal or moral qualms about the use of its long-term undercover deployments. So I'm going to move on now to the topic of justification and value, if I may. And I'd like to say this by way of introduction. The inquiry's terms of reference require it to identify and assess the adequacy of justification of undercover policing. Identifying the contemporaneous justifications for the STS's deployments, as opposed to the adequacy of those justifications, is relatively speaking a simple task. The general aims of the STS at their highest may be summarized in these terms. In furtherance of the responsibilities and function of Special Branch, as set in the 1970 terms of reference, the STS obtained intelligence that could not be obtained from other sources and which assisted Uniform Branch in policing public order and assisted the security service in its counter-subversion work. The available evidence shows that the STS was widely believed to be, and was, successful in meeting those two goals, which in the late 1960s and 70s were closely intertwined, as I have said, as public order was often fomented by groups whom the security service judged to be subversive. Contemporaneous justifications can also be identified within documents prepared at the time, including the STS's annual reports, MPSB's annual reports, and then exchanges between the MPS and the security service, and within government-level papers that the inquiry has published. Further contemporaneous justifications can and should be identified by inference from the historical context. These would not, of course, have been recorded, but may well have been apparent to the managers at the time. The inquiry can't be confident that it has secured all that type of evidence at this stage. The thornier question, sir, is whether the contemporaneous justifications were adequate. It's not clear how the inquiry intends to approach its assessment of this. It may be at a high level, as CTI attempt in their opening statement for Tranche 1, Modules 2B and 2C, or it may be more detailed, year by year, group by group, deployment by deployment, or report by report. A more detailed and contextualized approach is in principle preferable, but would of course require a complete evidential picture, which is lacking, so care must be taken. With a view to assisting the inquiry, the MPS has sought to evaluate in summary form the evidence that the inquiry has so far obtained in respect to the principal fields into which the STS deployed. That is the Vietnam Solidarity Campaign, the Stop the 70 Tour, the International Socialists, Socialist Workers' Party and splinter groups, the Socialist Labour League and Workers' Revolutionary Party, the International Marxist Group, Maoist groups, anarchist groups, and Irish support groups. This analysis is contained in Appendix C to the written submissions, which should be read alongside Appendix B, a chronology of relevant historical events during the T1 period, and Appendix D, a summary of the STS's work in the specific context of the Battle of Lewisham in 1977. So I'm not going to attempt to summarize those documents today. Instead, I'd like just to make a few comments about the question of justification and then look briefly at the conclusions that can be drawn from the available evidence. First, and most importantly, the MPS frankly acknowledges that special branch officers who authorize the deployments by the STS did not consider their intrusive nature and the right to privacy of the individuals targeted. nor did they balance these factors against their value. For them, the value of the intelligence that the STS produced, and it's clear they thought it did have high value, was ample justification by itself for its continuation. In failing to recognise or consider the intrusive nature of the undercover work, MPS officers were acting in alignment with the general undeveloped appreciation of privacy at the time within the police, the Home Office, which authorised the STS's work, the Security Service, which received and used its intelligence, and the Cabinet Office, which consumed intelligence on the groups that the STS infiltrated. This would not occur now. Applying modern policing standards and under the current legal and policy framework since RIPA. However, it would be wrong to judge the MPS and MPSB officers who authorised each of the STS's deployments by simply applying modern standards. They were seeking to fulfil their responsibilities without the benefit of a legal and regulatory framework, and in an era where privacy rights were not as highly valued by society and had not yet been articulated in domestic law. Second, the way in which the STS operated in this period was generally to undertake long-term, open-ended undercover deployments into groups. This meant that a continuous stream of intelligence on public order and subversion was available. UCOs were then well placed to gather specific intelligence on plans of public disorder in advance of it occurring, or to confirm that anticipated disorder may not occur. The MPS acknowledges that this methodology, which has been described as hoovering up information over long periods of time, led to the creation of many reports which at an individual level may not have been significant or valuable. It would be right to say that the existence of some reports of lesser relevance, it would not be right to say that the existence of some reports of lesser relevance undermines the overall adequacy of the contemporaneous justification. But the MPS fully accepts that there may be a tipping point where reporting that is made consistently of low value over time is inappropriate. Third, the type of detailed direct intelligence that the SCS's UCOs routinely produced couldn't have been obtained by any other means that were then available to the MPS. Open communications, attendance at public meetings, the use of informants, or indeed interceptions. Each of the groups planned their activities in private or in secret, and many individuals were security conscious. Such methods simply wouldn't have captured the quality and quantity of intelligence on the problems of public disorder and subversion as they were perceived at the time. Fourth and finally, the MPS would like to address a phrase or concept that has become something of an undefined shorthand within the inquiry. It has been suggested that there was some form of prohibition on a UCO taking up a, in quotes, position of responsibility in a target group. That phrase wasn't used contemporaneously, and there was no such prohibition. The correct position is that a UCO was expected to be a follower, not a leader, and not to influence the direction of the group into which they were deployed. There was value in UCOs assuming positions such as secretary or treasurer, in which they could exploit access to better information about their targets, so long as they were able to do so without crossing the line between follower and leader, or into agent provocateur. That value should be acknowledged. Counsel to the inquiry questioned whether a desire to maintain a police response characterised by having sufficient but not excessive police numbers is a valid one. With respect, it plainly was and is the desire of those in leadership positions that this should be achieved insofar as that is possible. Despite its efforts, the inquiry is not in a position to assess whether during each event within the T1 decade, many of which can be seen in the chronology at Appendix B, the policing decisions on the ground were positively or negatively, or not at all, affected by STS intelligence. The inquiry's investigation simply doesn't allow for this, given the absence of relevant intelligence and pre-demonstration assessments, and the absence of a comparative analysis of alternative European-style models of policing. With respect, it is simplistic to advance the point that it's hard to identify a single instance in which the STS intelligence averted a public order calamity in the T1 era. The fact that there were few such calamities is itself evidence that the system to which the STS contributed was working. Demonstrations were policed effectively. Those involved with gathering intelligence and policing public order were not going to record for the benefit of posterity their hypotheses on what might have happened at each demonstration if it had been differently policed. The evidence that is available to the inquiry in fact provides strong support for the general conclusion that the STS's intelligence made a valuable contribution to public order policing. And this includes the contemporaneous documentary evidence, which I've referred to, the evidence given by the STS's officers and managers to this inquiry, and the evidence given by A8 officers, for example, Anthony Speed, who said in his unchallenged witness statement, "We in A8 could not have done our job without the special branch assessments. Quite frankly, we could not begin to design an operational plan until we knew where the demonstration was taking place, how many people would turn up, the expected violence, and whether there was to be any opposition. Once we knew this, we were able to talk about the number of uniform officers and the command structure required." The evidence obtained by the inquiry also indicates that the SES's deployments furthered the MPS special branch's second function, the provision of intelligence to the security service on groups that the service judged to be subversive. STS reporting was routinely provided to the service, and Special Branch answered a stream of requests for information throughout the T1 period. Witness Z, on behalf of the security service, accepts the value of this intelligence, and his conclusion has not been challenged by the inquiry. Their conclusion has not been challenged by the inquiry. The limited number of Cabinet Office documents that are in evidence, although not commented upon by Witness Z, also established that the groups targeted by the STS were of genuine concern to the government throughout the T1 period, and that assessments of their activities and intentions were considered and relied upon at the highest level of government, including within the Home Office, the Cabinet Office, and by the Prime Minister. Important relevant documents are missing, however, from the Cabinet Office papers. For example, the reports of the Interdepartmental Group of Subversion in Public Life, which senior officers in Special Branch were entitled to receive, and also missing are the minutes of the Committee of Ministers set up in 1972 and chaired by the then Prime Minister, Sir Edward Heath. Nevertheless, as CTI observed, the available records clearly demonstrate a consistent appetite, it appears without reservation, for continuous, detailed intelligence about subversive groups throughout the T1 period, complemented by a desire to take active steps to counter subversion. It's incontrovertible, sir, that the STS's intelligence contributed to this process and to the security services' efforts to closely monitor each of the groups they identified to be subversive. So I'm going to turn now to the discrete topics of training, personal reporting and language, criminality, and the use of deceased children's identities. The inquiry's evidence demonstrates that STS officers didn't receive formal course-based standardized training for their undercover roles. The MPS accepts that in the field of modern undercover policing, as in many other types of policing work, formal training is an essential tool for fostering professionalism, honing skills, and developing resilience. However, policing culture was very different in the 1960s and 1970s, and in particular, there were no formal standards for undercover police deployments. In respect to the STS's initial operation between August and October 1968, its officers were not recruited to a pre-existing role, and in some cases, the work of these initial recruits went little beyond the type of inquiries plainclothes MPSB officers might conduct, save that the undercover officers would have a backstory to rely on and a false name to give if challenged, and then returned to meetings again and again. Thereafter, as the work of the STS extended, those in charge might fairly have concluded that the expertise in how to carry out an undercover role resided within the unit rather than in any external course. For this reason, the method of training developed whereby an officer due to be deployed would spend a period of time in the back office of the STS, learning about the type of reporting being carried out and the type of work being done by existing undercover officers, by processing that intelligence and visiting the safe house for regular meetings and debriefings. There can be no doubt that those in charge of the unit considered this period to be training, i.e. on-the-job learning, a pathway analogous to an apprenticeship. In a similar vein, whilst there was no formal in-deployment training, officers expected to receive informal advice and instructions during STS meetings throughout their deployment. Those in charge of the STS would have appreciated that they could rely on the fact that in almost all cases, the new recruit was an MPSB special branch officer. This would have meant they'd undergone a rigorous selection process and a training program. By 1979, at least, Special Branch ran 6 initial training courses and 2 advanced courses annually. The initial course included sessions on the role of special branches and MPSB structure, the role of the security service, police security service liaison, an introduction to the threat from subversion, subversion in industry, Trotskyists, anarchists, and the alternative society, subversion in the UK coloured community, as it was then called, A8 public order, the ultra-left, public order in the industrial field, Trotskyists and public order, and right-wing extremism. The advanced course included sessions on the role and responsibility of the security service, an introduction to the service's study of subversion, the ultra-left, international communism, current problems in the subversive scene, and left-wing current priorities, together with a session on A8 branch and public order. It's also clear that for the purposes of detailed written guidance, Special Branch had its own comprehensive standing orders at this time. And STS officers would also have, to a lesser or greater degree, some experience of Special Branch inquiry work. Routine work required officers to attend the meetings of activists, as I've said, sometimes discreetly. In addition, selection for the STS was typically on the basis of personal recommendation, thus indicating that the recruit's attributes had impressed an STS officer or manager. While there was an expectation that soundings would have been taken, this approach must now be recognised to lack transparency. However, such approaches were far more common across many policing and non-policing areas in this era, including, of course, the legal profession, than would be the case today. However, the MPS accepts, particularly in the light of the sexual misconduct of STS officers and the topics that I will now address, that it's abundantly clear that considerably better training, guidance and support was needed than was provided to the STS officers at the relevant time. Turning then to personal reporting and language. The aims of the STS in this period are set out in its 1969 terms of reference, and they included identifying those who engage in preliminary planning or who take part in public demonstrations, and gathering and recording information for long-term intelligence purposes. This was an aspect of work which the STS did, which also supported the security service. There are a number of the examples, as I've said, of the security service seeking specific and general information about individuals involved in the organisations concerned. And this was confirmed by officers who gave evidence to the inquiry that they reported on individuals in this way, and that reporting would be passed to the security service. As the inquiry's evidence demonstrates, the SCS gathered and recorded personal information, such as personal descriptions and other information, such as details about individuals' addresses, house moves, vehicles, finances, associations, domestic arrangements, and employment. This reporting includes some highly personal details about individuals' private circumstances, events, or activities. In some cases, there is reporting about children. The MPS invites the inquiry to take into account 5 points when reviewing this type of reporting. First, the whole-scale hoovering carried out by the STS would not occur in the context of undercover operations today. The STS was operating in an era before careful, pre-planned, and proportionately assessed targeting of the type required by RIPA and the APP Code of Practice. These governing instruments recognise the particularly intrusive nature of undercover policing, and through the concepts such as collateral intrusion, seek to minimise intrusion into the private lives of those who are not the target of the deployment. Second, even in the environment the STS worked in, i.e. without a clear framework for assessing the risks of intrusion and minimising collateral intrusion, some of the language used by the officers in some of the reports was not acceptable. This includes rudeness and derogatory and arrogant language, which was objectionable even at the time. it had no intelligence value and it's not defended. Put simply, it shouldn't have occurred, and when seen by managers, it should have been amended and the issue explained to the reporting officer. Third, officers shouldn't now be criticised for the use of language and terminology which is unacceptable now but wasn't considered problematic at the time. An example of this is the use of a word such as coloured, which would not be used now, but which was commonplace during that period. And examples of this can be found in many places, including in Parliament. Fourth, the inquiry should appreciate that many categories of personal information are capable of being relevant and valuable for intelligence purposes. Personal reporting is not improper per se, even highly personal reporting, which may be valuable and justified in certain circumstances. Examples of this are considered in detail in the MPS's written statement. Finally, it would not always have been obvious at the time or be clear in retrospect which intelligence was valuable and which should have been sought, not have been sought and kept. Even when giving evidence, many SDS officers didn't appreciate what value individual items of intelligence might have been capable of having. And in an operational context, this is understandable, particularly in respect of information where the greater intelligence value was to the security service rather than the police. The decision whether a piece of intelligence is relevant or of value was and is for the analyst of that intelligence, not the undercover officer reporting it. Further, as the MPS stated at the start of T1, intelligence can have a latent value that doesn't manifest until some time after it has been gathered, or has been gathered but ended up being of little value if the individuals or groups targeted proved to be harmless. But that is only a judgment that can be made in retrospect. In summary, sir, it may be appropriate to report and to retain even highly personal, private information in the context of a properly justified deployment. The inquiry is therefore urged not to make any finding at the level of generality about any class of information being off limits for intelligence purposes. However, it's recognised that no special or directed guidance was given to SDS officers about the types of reporting that were plainly sensitive and personal. The MPS accepts that it should have been clear to managers from the early days that SDS officers had access to far more personal and private information than was available through normal MPSB inquiries. It would have been beneficial for some form of guidance on this topic to have been given to undercover officers to ensure that reporting remained relevant, necessary, and ethical, and was only retained with good reason. It's clear that this type of consideration simply was not in evidence in the intelligence community of the time, many years before RIPA. Just as the evaluative exercise, which I've outlined in respect of the overall deployments, wasn't in place, but should nevertheless have been given some consideration. Criminality. The guidance in respect of engagement in criminal conduct, which was in operation from close to the beginning of the T1 period, was the Home Office Circular 97/1969, concerning the use by the police of informants who take part in crime, the salient parts of which are quoted in the MPS's written statement. Although it's not plain on its face that this circular applied to police officers in addition to civilian informants, it should have been clear from at least two 1974 criminal cases, McEverly and Lee and Mealy and Sheridan, that it did. Unsurprisingly, few of the SDS officers who gave evidence to the inquiry recalled the circular by name or recognised it in its original format. But its central principles, at least insofar as not acting as an agent provocateur, were broadly understood by the majority. Some recalled this type of guidance being given expressly in the context of the SDS's work, others did not. Roy Creamer, for example, suggested in his evidence that the rules were clear within the SDS from the outset. Many UCOs have informed the inquiry that law breaking was not an issue in their deployments, as the groups into which they were deployed were not engaged in criminal conduct. However, a number of UCOs were involved in fly posting or conduct during demonstrations which would amount to obstruction, both of which appear to have been tacitly authorised and treated at the time as being the type of conduct necessary to show the requisite enthusiasm for their role and to maintain their cover. However, in the MPS's written closing statements, it considers four specific case studies in which SDS officers engaged in criminality. I will not repeat those now, but it may be thought that certain themes arise from the examples given. In particular, the fact that there were no clear policies for managing the involvement of UCOs in the criminal justice system and for managing undercover officers' knowledge of legally privileged information. Second, the fact that the courts were repeatedly misled by not being informed that undercover police officers were appearing as defendants. Third, the fact that managers didn't take appropriate disciplinary action in response to criminal conduct by an undercover officer, which will no doubt be a matter that the inquiry will wish to consider further in the conduct of the management of SDS deployments in later tranches. So those are matters where the MPS recognises that criticisms can and should be made. And finally, as the closing statement acknowledges, the inquiry may want to give further consideration to referrals to the miscarriage of justice panel. The use of deceased children's identities. The MPS acknowledges, as it did at the start of the Tranche 1 hearings, that insufficient consideration was given by the SDS to the impact the practice might have had if revealed or discovered on the families of those concerned. That impact was neither intended nor foreseen, but for the families, it has been significant, and the MPS apologises again for the shock and distress that they have suffered. It's not clear precisely when the SDS first started using deceased children's identities or what indeed prompted it to do so. There's some evidence to suggest that the practice was popularised by The Day of the Jackal, a novel published in 1971, but this is far from conclusive. Whatever the correct position, the practice was already in use by the time the managers who provided evidence to the inquiry joined the SDS, and they either authorised its continued use or informally maintained the pre-existing practice. From the mid-1970s, it was standard practice for UCOs to use children's identities as part of their legend building. This corresponded with an increase in the length of the undercover deployments and the move to infiltration of more security-conscious organisations. These two factors created a significant ongoing risk that the UCOs' false identities would be uncovered, thereby terminating their work and, more importantly, exposing them to a real risk of physical harm. It was therefore essential for UCOs to create credible identities that could withstand close, proactive scrutiny, including checks of birth records, which at the time were publicly available in hard copy at the General Records Office. It wasn't possible at that time to falsify entries into these records, so using the identity of a real person was considered necessary for safety purposes. It also had the secondary advantage of giving UCOs access to hard copy birth certificates, which they needed to obtain driving licenses and passports in their cover identities. The person in question needed to have been born at about the same time as the officer to avoid suspicion as to the disparity between age and appearance, but it could also not have been a living person who might have been known to a member of the group or discovered by research or accident, or by dint of deployment, gain a special branch file. For all these reasons, it needed to be someone who had died. The use of a deceased person's identity still itself carried an inherent risk that the UCO's death, in inverted commas, would be exposed by reference to the corresponding public records of deaths. Using the identity of a child was believed to minimize this risk by maximizing the difficulty of finding the associated record. It also meant that other personal records that could jeopardize the UCO, such as employment or education records, would either be non-existent or difficult to find. A hostile researcher may not have thought to look for the death of a child, or may not have wanted to search many years of historical archives. The manner in which records were kept in separate ledgers made it more difficult to establish a link between birth and death, particularly in circumstances where a child had been a little older when they died, because birth and death certificates wouldn't have been located close to each other. In summary, sir, in the T1 period, the use of deceased children's identities was believed to be the only effective, practical and safe means of preserving STS officers' false identities over the course of their long deployments. While the practice wasn't entirely itself without risk, it remained the securest method available. And this view prevailed, notwithstanding the fact that the link between birth and death had been established during the deployment of one officer, HM297, and had led him to be compromised and withdrawn from the field. During this inquiry, no one has yet identified an alternative method which would have been as effective and as safe at the time. And the inquiry is asked to accept that this was a necessary practice in all the circumstances, or alternatively, that it was reasonable for the STS's managers to have believed it to offer the best and safest solution. In its opening statement for T1P3, the MPS formally requested that the inquiry investigated whether the practice of using deceased children's identities originated, or where it originated, including whether it was used by other UK state bodies such as the Security Service prior to its use by the STS. So the answer to that question may be felt to be important. It is directly relevant to the assessment of whether the use of the practice may have been reasonable at the time, because it represented standard practice within the intelligence community. And it may also be relevant because it would objectively confirm that there were no other practical and safe methods for preserving the long-term security of UCOs or other covert human intelligence sources. So at the start of that hearing, you declined the MPS's request on the grounds that it wouldn't illuminate the origins of the practice within the STS. Following this, the MPS wrote to the Security Service directly to ask if they would clarify the position. However, they also declined to do so. From the MPS's perspective, these responses have caused a significant missed opportunity to assess the use of deceased children's identities by reference to its proper historical context. So I've now concluded the main body of my submissions almost on time, and I would just like to make these very short remarks at the end, if I may. First, I would like to echo what I said at the start of the T1 hearings on behalf of the MPS, and that is that the inquiry continues to have the absolute commitment of the MPS in its work, and the MPS will assist the inquiry and will continue to assist the inquiry in every way it can. And second, I'd like to emphasize again that the MPS approaches the issues under investigation by the inquiry with humanity and with a willingness to identify and learn from the mistakes of the past. So that concludes my oral opening statement.
Thank you very much, Mr. Skelton. You've come well within the time that the inquiry was willing to allot to you, and I'm very grateful to you for doing so. It will reduce the pressure of time under which we all operate. Thank you.
Thank you.
We will now resume at 2:05 with Mr. Sanders for the DL team. Thank you.
I did cut it right down. I hope it was helpful. It's very difficult for you to hear the same thing again and again when you've read it, but I do appreciate that.
Your point about the use of human colour, I've always taken to heart, because the leading association for the